Innocence programs and news outlets around the state of Ohio are under attack due to the budget bill recently approved by the House. Buried within this 5,000-plus page document is a section proposed by the Ohio Prosecuting Attorneys Association that would deny media outlets, attorneys, investigators, law students, and the general public access to public records necessary to investigate the integrity of a conviction. To date, over 100 innocent people in Ohio have been freed from prison thanks to the work of organizations like the Ohio Innocence Project, the Wrongful Conviction Project of the Ohio Public Defender's Office, Cleveland State's Terry Gilbert Wrongful Conviction Program, and soon, Northwest Ohio Innocence Clinic. These successes could not have happened without the benefit of the entire investigatory file, including all supplemental reports, prosecutors' files, lab reports, witness interviews, Crime Stopper calls, and the like. The language in this rider is an invitation to allow police agencies to withhold any investigative report. All they will need to do is label it attorney or investigatory work product, and it could remain hidden, possibly forever. Lucas County Prosecutor Julia Bates, who supports this change to the law, stated, "We understand the proposed changes to the public records law and the potential impact on transparency. However, it is important to balance that transparency with the need to protect the integrity of ongoing legal proceedings." Danny Brown versus the state of Ohio is one of the cases Prosecutor Bates would consider ongoing. For almost 25 years, her office has fought Danny Brown's attempts to clear his name of the 1981 murder of Bobby Russell. Brown was convicted on the eyewitness testimony of the victim's young son. The assault on Russell was brutal. She had been beaten, raped, sodomized, and strangled with an extension cord. A broken table leg was used to tighten the garrote. After almost 20 years in prison, a DNA test exonerated Danny Brown and pointed to Sherman Preston, a man with a violent past who had sodomized and murdered another victim in the exact same way Bobby Russell was killed. But Danny Brown remains the state's prime suspect. Northwest Ohio Innocence Clinic is focused on training interns in the area of post-conviction investigation and, specifically, public records law. Thanks to Ohio's current public records statute, NWOIC has been able to find new evidence from this 1981 case. But more importantly, the deep dive into one of Toledo's most infamous murders illustrates how far some prosecutors will go to protect a conviction. And Danny Brown's saga illustrates that point. 44 years and counting. That's how long this case has dragged on. At the 1982 trial, the state's position was that there was only one assailant, Danny Brown. But after the DNA test excluded him, the prosecution focused on a statement young Russell made in one of his police interviews, that there were 2 men in the apartment that night. Prosecutor Bates and her team have maintained that, although Preston may have raped and sodomized Russell, it was Danny Brown who killed her. In 2003, they resubmitted some of the evidence for testing. A key, used by the assailant to enter the apartment, yielded a match to somebody in the criminal database. Somebody other than Danny Brown or Sherman Preston. A 2007 phone log from BCI showed that the prosecutor ruled out this person as a viable suspect. NWOIC has been trying for months to obtain the investigatory report on this suspect. The prosecutor's office has yet to disclose it. Nor have they disclosed what appears to be perjured testimony. The brutality inflicted on Russell begged the question, what kind of person could do this? Danny Brown did not have a history of violence, certainly nothing that would explain the horrors done to Russell. The state's case would be much stronger if somebody could provide motive. That somebody was prosecution witness, Randolph Lee McCoy, who testified to witnessing Brown's violent behavior. He said the victim had called him to her place on 2 occasions to, in essence, rescue her from Brown, who was throwing her things around. He said that Danny was rowdy and upset with Bobby Russell because she wouldn't give him money. McCoy also stated that he was asked to take Brown away because he was trying to move in with her. And he intimated that Bobby had called the police on Danny. In her final argument, Prosecutor Franks painted a picture of a violent, out-of-control defendant, capable of the brutality inflicted on Bobby Russell. 43 years after that trial, investigators are trying to learn what prosecutors did or did not know about this witness, and if perhaps a deal had been made with him. Bobby Russell was murdered on December 5, 1981. McCoy testified that there were 2 instances, both around Thanksgiving of that year, when he was called to her place to remove the out-of-control Danny Brown. But court records tell a different story. On August 12, 1981, Oregon police arrested Randolph McCoy for rape. The victim was a minor. There was a preliminary hearing on 8/26/1981, resulting in a bindover to Lucas County Common Pleas Court. His bond was $5,000, no 10%. McCoy was ordered into the custody of the Lucas County Jail, where he would remain until discharged by due course of law. The indictment shows there was enough evidence to proceed to trial. It also shows there was a co-defendant in the case, an Alfonso Creighton. Creighton, charged with a lesser crime, was able to get his bond paid, and it is so noted in his docket. McCoy's docket shows no such payment. However, it does indicate he had an indigency hearing, resulting in the appointment of counsel. So it stands to reason that he was in the Lucas County Jail throughout the fall of 1981, during the times he said he was rescuing Bobby Russell from the crazy and weird Danny Brown. Ruth Ann Franks, who became a common pleas judge in 1987, assisted in Danny Brown's efforts to get the DNA test that would set him free in 2001. But prosecutor Julia Bates continues to maintain that he is still a suspect. If true, why would her office request that all the exhibits be destroyed? Since their destruction, she stated, "Without evidence, we can't try the case." And there are so many questions. Yes, there certainly are. As a young assistant prosecutor, Julia Reinberger Bates represented the state in the 1981 rape trial of Randolph Lee McCoy, which resulted in an acquittal. Question: how did he become a witness for the prosecution in the case against Danny Brown? That answer might be contained in a 2001 interview with McCoy that the prosecution deems law enforcement privilege. Protect the public's right to know. Ohio's public records laws have nothing to do with the state budget, and any reduction to their transparency will not protect the integrity of ongoing legal proceedings. It will only further protect a bad conviction.